All right,
Oh,
everyone. It says that we're live, so that is a positive for us already. I'm Bernard Nomberg, the Nomberg Law Firm in Birmingham, and David, who is normally with me on these shows, is traveling today, and that's okay. We're going to go forward with our monthly work comp today. Today is April 27th, and we are so lucky to have our guest, Heather Long, out of Delaware. Heather, thank you for joining us today, and it's so great to see you.
of course. Thank you for having me.
Of course, of course, of course. And what we try to do on our monthly YouTube show is we like to go over the news of the prior month that involve employers, employees, and independent contractors. And we've been doing this show for about 3.5 years. And while a lot of the topics change every month, we a lot of themes have really, I guess, continued all the way through. Typically, Amazon is involved. Typically, the gig economy is involved. Pandemic, medical marijuana, you name it, and a lot of this you're going to hear again today. But before we get into our articles and talking about Delaware laws and Alabama laws, Heather, tell us a little bit about your practice in Delaware and a little bit about you and your family.
Sure. Thank you, Bernard. So my name is Heather Long. As you said, I am coming to you from the newly formed law office of Long and Greenberg. We were established February 1st of this year. So it's been about 3 months for us.
Awesome.
Brand new law firm. Thank you. Female owned, female operated. My partner, Alyssa Greenberg, also handles workers' comp for the employers or for the employees, and we handle personal injury cases. We're here in Odessa, Delaware. We're in the MOT area, so Middletown, Odessa, and Townsend. This is where my kids go to school. This is where I live. So this is now where I work as well. I'm proud to be the local personal injury and workers' compensation attorney.
Awesome. Well, David and I have gotten to know Heather and over the last couple of years with our organization that we all belong to, Wilg, and we'll talk about them in a few minutes, but it's what's always been so great for us, and I hope you've had this similar benefit, is when we go to these conferences, we get to interact with colleagues who do the similar type of work that we do, really from all over the country. And it really is, although the laws are different from state to state, the ideas and the philosophies about what we do as practitioners who help out injured workers it doesn't change a lot from state to state. That passion to help those who are injured and need us the most, I think, can be found in our organization. And I think that's what makes it so strong. So I hope you get the same benefits that David and I kind of see with all of these member of the relationships that we've developed.
Correct. I think the overall arching ideal is advocacy for the injured worker. And being in Delaware, we're a small state. We have Pennsylvania, Maryland, New Jersey near us. So there's a lot of things, as you said, workers' comp is state specific, but there's a lot of overplay between, the states in my area. Workers injured in Delaware, but they live in Maryland or vice versa, any of the other states. So I found it so helpful getting to know the other workers' comp attorneys in my area and seeing what they do and how they've progressed. Additionally, as I said, this is a brand new firm. So I was with another firm for many years, handling workers' compensation for many years, and then decided to go out on my own. And Wilg was a huge resource for me to be able to do that, especially the people involved, being able to draw on them and their knowledge and their background and their expertise. For example, we just had a Southeast Regional Conference in DC about a week ago, and I was able to interact and talk with a bunch of other attorneys, like-minded attorneys who, left and struck out on their own at some point too, and gave me lots of helpful hints and pointers and do's and don'ts to follow. So it's been a tremendously helpful organization to me personally, and I can see for the injured workers in general, with all of us coming together, putting our minds together, and really aiming towards that goal of advocacy for the injured worker.
Excellent. We certainly wish you the best with the new firm and lots of success.
Thank you. Thank
All
you.
right, let's jump into our articles. And our first one comes out of the state of North Carolina. North Carolina work injury tort settles for $5 million with another $5 million in comp benefits to come. And this is a nasty accident that occurred. And these are pretty rare in Alabama. They're probably pretty rare anywhere. But what are some of the practice pointers, or what are some of the things that, Heather, that stuck out to you that really things we need to, I guess, to highlight?
So the thing that stuck out to me, and here in Delaware, workers' compensation is typically the injured worker's exclusive remedy. However, and you see this a lot in construction cases, which is what this case was, this particular worker who was injured was not on the work site for his employer. So sometimes we'll see where workers will be borrowed from employer to employer, or they would be subcontracted from employer to employer. And this particular man was not being paid. He was not working for the person who was in charge of the job site. And that is one of the reasons why he was able to have the third party suit, or the case against the general contractors, because he didn't work for them. There's no employee-employer relationship there. So he wasn't barred by the workers' compensation exclusivity.
And another, not for us to this work comp practitioners get too deep in the woods here, but the other thing that comes into play that's very difficult for injured workers to first grasp is dealing with the liens, with subrogation. And here it looks like that work comp paid for over $1 million worth of medical care, and maybe paid him out some comp benefits. And so they had a $1.2 million subrogation lien, and they want to be paid back. So they really, although there's that exclusivity side of this, they had an incentive and hope that this would go forward and go well for the injured worker, so they'd get their money back. But as it says here, according to the attorney who handled it, he negotiated it down to $110,000, which is pretty remarkable for him. Great piece of lawyering there. But you're so right. There's many times in these construction cases, you've got to figure out who all the parts are, who are all the parties to this, and who got paid and who instructed whom. And sometimes it takes quite a while. And a lot of times, Heather, if we can't figure it out, the old adage is just sue everybody and let the judge sort it all out. And that may not be great, but sometimes you just can't tell until you start deposing folks.
Right. And especially with statute of limitations here in Delaware, it's 2 years on the third party case. So you want to get everybody in there within the 2 years, and then you can start letting people out. But you don't want to miss any major players in the game.
No, you're so right about that. Those are probably, to me, some of the highlights that I saw. Was there anything else you wanted to highlight on that, or to chat about before we moved on to our next one?
Well, so the other thing that I thought was interesting about this case was he was able to sue other subcontractors. So not only could he sue upstream, but he could also sue, next to him as well, to the other subcontractors working on the site. So this all goes back to, really job safety. We need to, I think these construction companies really need to do a better job with construction safety, making sure that things are marked properly to try to avoid situations like this.
Well, there's always that balance between their expenses versus what they hope to recoup in money. And anyway, that could be a whole subject, a whole hour just on its own. But
right.
Not straying too far from your part of the country, we're gonna move over to Pennsylvania, where work comp, it says workers' comp takes a bite out of employees' right to sue third party, according to the Pennsylvania High Court. And again, unless you practice this type of law, these kind of cases, you may read a headline, but if you don't do this, you're just going to move on. But gosh, we dig deep into these kind of cases, because you always, no matter what state they occur in, Heather, there's always something, at least in for me, and probably for you as well, there's something in every article you could take away, maybe as a practice pointer for your own practice, or maybe to share with folks in your firm. Do you ever find yourself reading other states' cases, not just coming on this show, but then figuring out how it could benefit you guys?
I completely agree. I completely agree. And the lawyer in this case was so creative, I thought, in his arguments.
Mhm.
So essentially, what happened was this injured worker worked at a Home Depot type of store, Home Depot, Lowe's,
Yeah.
and somebody brought a dog into the store, and she was bitten by the dog. And then the employer did an investigation, but didn't take any information about the identity or contact information of the dog owner. So the dog owner waltzed away from the store, and this woman's attorney came up with a very creative argument, I thought, as a way around the workers' comp exclusivity doctrine by saying, you know, employer, you barred her from being able to have the information that she needed to file her third party claim. Therefore, you stand in essentially in that person's shoes and you pay her what she's owed. Now,
How do you
it
think
didn't
this would
go.
apply? How would this fly in Delaware?
Well, I think Delaware would probably come down the same way that Pennsylvania did. So unfortunately, it just was not in the injured worker's favor. They said, no, this, you know, you're still barred in this situation by the workers' comp exclusivity.
Yeah, I do. I give this attorney a lot of props for making this attempt. I think the same result would occur here in Alabama, but that exclusivity provision is just so ingrained, if you will, that
Mhm.
even the best or worst of fact patterns for an injured worker sometimes is not going to allow you to move around. And that's really what I wanted to highlight was the exclusivity part of this. And it stinks that you couldn't get another bite at the apple. But
Right.
anyway, I think I don't know if there's really anything else other than, that's just pretty crappy on Home Depot and its
Yeah.
workers for doing that.
Yeah. Well, I mean, there's trade-offs for the exclusivity. So because of that, you know, the injured workers don't have to prove negligence on somebody else's part in order to qualify for workers' compensation. It just stinks for this particular person that, you know, she wasn't negligent. She could have brought a claim against somebody else for her injuries, her damages, her pain and suffering. And her employer just let that opportunity literally walk out the door for her.
Yeah, no, that's absolutely true.
Mm-hmm.
All right, Heather, let's move on to our next article. And I think a lot of this is impacted to me by the pandemic. And now that what are we, 3 years and a month or two since it really kind of kicked into overdrive in March of 20, I think enough time has passed that we're seeing a lot of studies and information to come out about how it's impacted in the workplace. And our article really is more nationwide, but it really, the title is What's Contributing to the Rise in One Sector's Work Comp Claims. And it really, to me, is not a shock that it deals with the restaurant industry. I don't know about you. I don't know how life is in Delaware about going out to restaurants and things. Alabama's never really changed much, if you will, but that's just our state. I know that a lot of restaurants, even now, have sections where they just don't have enough servers, so they just shut down whole portions. Our very best, highest rated restaurant in our state, it's about 3 miles from here, gets all the awards. They still have not opened in more than 3 years because the owner is just that committed to finding staff that are fully trained up to his standards, et cetera. So he just remains closed, which is a real shame because it's a fabulous restaurant. But anyway, too much about that. What did you take about dealing with the restaurant industry?
Well, I saw in the article, it mentioned that mental health claims were up by 71% as compared to pre-COVID levels.
Mhm.
And I am absolutely seeing that in my practice, which is not specific to the restaurant industry. I'm seeing that across the board.
Absolutely.
Delaware is difficult because mental health claims, I feel, don't get enough attention. There's not enough providers. There's not enough people willing to take those cases because in Delaware, it's not considered a permanent injury. And so we can't qualify for permanent impairment benefits for these injured workers. Therefore, there's not very many attorneys willing to take on those cases. But I've seen a lot of mental health types of cases on the rise, with my first responders, police, fire, EMS, teachers, even, with these mental health claims, that I think COVID perhaps made people so that they lost some of the kindness, some of the filter. People are used to talking to other people through a screen, similar to what you and I are doing.
Yeah,
But
they sure are.
it makes them say things that I think they otherwise wouldn't say in person. And coming back into the real world, I think some of those inhibitions are down, and people are just not used to interacting face to face with others.
Heather, does Delaware require a physical injury to accept a mental injury in the work comp setting, or can you have just a straight mental injury as a claim?
You can have just a straight mental injury as a claim. That's perfectly acceptable. However, the way that the attorneys here in Delaware get paid is on that permanent impairment piece of the case. So without having that, there's not a lot of attorneys that are going to take on a mental stress only claim.
Yeah, and as you can probably have imagined, Alabama requires a physical injury to have the mental injury accepted. And then the way that the typically happens, as soon as the physical injury reaches maximum improvement, adjusters just cut off all mental claim medical care as well. So we have to go back to court to fight for that in a lot of instances. But with these, I did think this was interesting. Go back to our article, the most common restaurant injuries: cuts, punctures, and scrapes. I could see that with knives or forks or scissors and so forth in the kitchen. The average payout. Now, I guess when it's saying average payout, is that maybe the settlement amount? It doesn't really specify, but it says $1,519. That just doesn't seem. Anyway, falls and slips, I can see that. Average is 10,000 and some change. Strains, I guess that maybe is lifting something that's too heavy or you moved wrong. It's about 9,200. And then burns and scalding injuries, about 3,100. And this is where I wanted to ask your experience or knowledge about this. Our cases, and maybe I've just had a run of really bad burn cases, not necessarily just in restaurants, but it seems like the ones that I've had in the last couple of years, it's been large portions of the body. And when it's disfigured, it really creates the inability to move the way that you should if you have a physical type of a job. So there is a large, potentially vocational disability claim, meaning they can't go back to the old job or earning the same type of money. So those burn claims have been much higher than $3,100 on average for me. Do you have any experience with burn cases? Have you dealt with those?
Right. So the burn cases that I've dealt with regards to restaurants, thankfully have not been that catastrophic. Typically, it's a burn on the arm, a burn on the leg, and people are able to get back to their job. The severe burn cases I have not been restaurant cases, but you do have to worry about, the contracture and the skin and keeping it covered, and the different sunblocks that you need to do, and braces and things that need to be worn. So those more significant cases, absolutely. You need to think about job retraining. You need to think about, what are they going to do in terms of getting more education or figuring out another job that they can do that those things won't become an issue.
Yeah, we have a couple of chemical lime plants not too far from Birmingham where we practice. And sometimes we'll have truck drivers who will, I'm thinking of one specific case where the lime escaped from the back of his truck and he was in the wrong place at the wrong time and covered about 68 to 70% of his body in chemical burns. Just horrible cases sometimes, but that's getting the far afield. Guys, I want to welcome, if you're just tuning in or if you catch us on the replay, I've got Heather Long with Long and Greenberg in Delaware. This is our monthly live YouTube show, Work Comp Today, where we address current topics and news about employers, employees, and independent contractors. And before you get worried, where's David? Where's the co-host of the show? He hasn't boycotted. We're not fighting. He just happens to be out of town on business, so he could not join us. He'll be back next month. And so you guys don't worry, we'll have him back, and he'll give us his wisdom and his snarkiness as he always does. But Heather, I want to move on to our fourth article. And this really applies, and I brought this one up because any work comp practitioner has dealt with this, if not weekly, maybe daily or hourly in their practice. Common reasons why workers' comp claims are denied and how to avoid them. And I'm going to let you just kind of lead us off. What were some of the highlights or the lowlights that you saw in there that I know that you advise your potential new clients all the time on these topics?
So one of my absolute least favorite reasons for denial, and I can't believe that this is even still a thing, is that there was no eyewitnesses.
Right.
I was talking with a colleague today about a science teacher that we represented who had a chemical explosion and lost some fingers on a hand, and the insurance company had the gall to say, well, it wasn't witnessed, so how can we be sure that, this isn't pre-existing or something crazy like that? It's just absolutely ridiculous. So if you see a denial like that, there's no eyewitnesses, you can't just take that in a vacuum. You have to look at the bigger picture. Is there objective proof of an injury? Is there something else that will connect this injured worker to the injury that they say that they've sustained? Yeah. Do you see that one in your practice much?
Yeah, all the time. And the easiest way to prove or disprove that is also goes into the other most popular denial reason is the injury is not work related. Well, what do the medical records have to say? What does the ER record show about the history of why they're in the ER to begin with? Are those records, because you got to build that chronology to see if there's consistency. And that consistency, what we always preach to our clients, our potential clients as well, if you're not believable, if you're not credible, why should I believe you? Why should an insurance adjuster believe you? Why should a judge believe you? Does the story make sense? And really, Heather, for all of these, the injury not being work related, was there horseplay, intoxication? I could go down that whole list. It's the credibility factor. And this is what I wanted to ask you about that. How do you guys, in your practice, how do you stress to those clients who claim to you, because we don't know them, they don't know us until we are interacting with them. How do you build that credibility or maintain that credibility for your client's claim?
In Delaware, I feel like cases are won and lost on credibility all the time. Credibility is everything. And it starts with, for me, my client's first interaction with the insurance company. Here, they're not allowed to take depositions of my client. So the first interaction is when my client goes to see the insurance company doctor at a defense medical evaluation. I let the client know what the doctor's going to be like, what kinds of questions they're going to ask, and let them know, look, this doctor is going to know you better than some of your best friends that you have dinner with every Friday night. So there's no sense in trying to hold anything back, trying to cover anything up. Tell it like it is, be honest, be upfront, be truthful. Don't over exaggerate anything. But also don't try to be a superhero and minimize everything either. I see that a lot with the first responders that I represent, the police, fire, and EMS. They are tough people, tough workers. And so when they go to see these defense medical examinations, they tend to minimize their complaints. Conversely, you'll see some clients that over exaggerate, and neither one is correct. So there's a fine line to walk down the middle where you can be personable, you can be credible, you can tell it like it is without, giving the doctor too much information. And I think that goes a long way in establishing the tone of the case, because after that doctor sends a report to the insurance company, that goes to the attorney, and then that sets up their theory of the case from the defense side. So I feel like that's a pivotal moment, is that first interaction that the client has with the defense doctor.
Oh, absolutely. And those are just, I hope that whoever's watching this listens to what Heather just had to say, because it's so very important. It's just the credibility. You could have the worst injury in the world, the most horrific accident. You could have 50 people who saw what happened. But if you, the injured worker, are not credible, if you're not believable, it won't matter. It really doesn't. All right, Heather, let's pivot, because again, each of these articles, we really could talk for the entire session about each of these topics. That's how much of a work comp nerd, as David calls us, we can be when dealing with these matters. But the last one, this is your home state. Hopefully this is right in your wheelhouse. Court blasts accident board for unsupported order to end workers' drug therapy. Tell us, what do you take away from this one?
Yeah, so this one hits close to home. This is a case that was decided by the Superior Court only about a month ago. And this is by Judge Jones. I used to actually work for Judge Jones when I was in law school. I was a paralegal at a firm that he worked at. He's now risen to the bench and has issued decisions such as this one, which, as I read it, it was a little spicy, I thought. He was pretty critical of the board, which we do not see here in Delaware. Everybody's very kind. In Delaware, we call it the Delaware way. Everybody's nice to everyone else. Everybody offers favors. Everybody offers a hand up. And I was a little bit surprised to see that he was so critical of the Department of Labor, the Industrial Accident Board, in this. So essentially what happened is this woman worked for Delaware Park and essentially had a compensable work injury about 20 years ago. Workers' comp paid for a surgery 18 years ago, and they've been paying for her pain management care over the last 18 years. Well, I suppose that at some point they just said enough is enough, and let's see if this is still reasonable for us to pay for this treatment. And their doctor, Dr. Townsend, who also practices both for the insurance companies and for the claimant side, so he is very middle of the road. He calls it as he sees it, and is very, very well respected in our community. He said, well, you may want to consider tapering this injured worker. If they are okay with the taper, you can keep on reducing the medication dosage. But if they're not okay with the taper, then you shouldn't reduce it. And he was the only expert that testified at the Industrial Accident Board hearing. And based on that testimony, the Industrial Accident Board issued an order saying, you must taper this medication within 6 months down to 0. And Judge Jones said, that is not what the doctor said. He did not say that you need to taper down to 0. He did not give a date certain. The Department of Labor cannot stand in the shoes of this patient's, this injured worker's doctor, and they can't make that decision for the doctor. So he reversed and remanded it and sent it back down to the Department of Labor.
And I guess there hasn't been a public finding or other order issued yet. But when I was reading through this, I was like, I like this judge. I like how he went to bat and just kind of leveled the playing field, as you would hope. But interesting outcome. I know that you guys are following this and waiting for the next public order, or whatever gets published in this. Well, it's, I always, whenever, like I said earlier, whenever I read these, I'm like, how would our court, how would it be handled in Alabama? And I don't know that this type of ruling would come forth in Alabama. I guess it depends on whether it would be with the Supreme Court, which is a little more conservative than our Court of Civil Appeals. There's 2 different routes you can take depending on how the appeal is done. I think I'd rather have mine with the Court of Civil Appeals because they seem to be a little more lenient toward helping out the workers from that standpoint. Well, Heather, those are our 5 articles for this month, and I appreciate you going through them with us. But before we finish out each of these programs each month, I like to take 3 or so different areas of the work comp practice from the state of Alabama and compare them with how the home state of our guest, Delaware, handles things. And so the first of these 3 is dealing with medical marijuana in the work comp process. it's not going to be a big stretch for you to learn that there is no law allowing it in our state, as most things are extremely conservative, and this is no different. But in Delaware, has medical marijuana made its foothold? Is it permitted by law or by practice with work comp cases?
It is. And the way that Delaware has handled this is that the injured worker would need to go out to a doctor, get a medical marijuana card, get the medical marijuana, and then submit their receipt for reimbursement. Typically here in Delaware, the insurance companies require reimbursement be on a specific form. And these medical marijuana dispensaries are just typically not set up to write those types of forms. So there's been a little back and forth in terms of paperwork. But I've also had, on the flip side, conversely, some attorneys on the defense bar reach out to me and say, hey, we're paying all this money for all this pain management. Would your client be interested in medical marijuana? We think it would be more effective. It would be cheaper. And exactly. And would your client be interested in it? So it's all over the place here, but we do allow for it on a case-by-case basis if it can be proven that it's reasonable, necessary, related to the work injury, and then the insurance company would reimburse the injured worker.
Now, along those same lines, in Alabama, and I suspect in Delaware too, injured workers who are undergoing medical care, whether it is surgery or therapy or whatever it may be, if they're also being prescribed medicine, whether it's anti-inflammatories, pain medicine, whatever it is, they're always going to be subjected to drug screens. And so my question is, how are drug screens treated if an injured worker in Delaware tests positive for something that is banned, like some type of an opioid or higher levels than what are accepted? Are there any changes to the benefits that they may be entitled to?
There's not necessarily any changes to the workers' comp benefits if they test positive on a drug screen. However, there may be repercussions with the employer. So just because they still are eligible to receive workers' compensation benefits does not necessarily mean that they get to keep their job. So if the employer gets wind of a drug screen that shows marijuana or cocaine or any other illicit substances, even their pain medications at times, then that could be a reason that the employer could effectively terminate them. But they still keep their workers' compensation benefits. If it is something that the employer is taking a medicine, the pain medicine, then they may have a claim on their hands with regards to ADA. But that's a whole other conversation for a whole other day.
And just to make sure so I've got it clear in my head, are they still entitled to medical care benefits and either weekly or biweekly comp benefits, or at the end of their case, either a settlement or a judgment? Do all of that stay in place, even if it's a positive drug screen for something that's not permitted?
Yes, absolutely. The only way that the employer can get away with cutting off these work injury benefits, there's very few ways. So the first way is statute of limitations, which here, once the case is accepted, you have a 5-year statute of limitations from the date the last benefit is paid. So benefits here last many, many years, decades even. So they could be in violation of the statute of limitations. There could be a forfeiture defense, but that usually comes in the beginning of the case where the person was either drunk or high or using some sort of illicit substance when they became injured. And that would allow the employer to forfeit benefits from the beginning of the case. But once the case is ongoing, the relationship between the employee and the employer does not have a huge effect on the workers' compensation benefits. Those workers' compensation benefits survive any adverse action that the employer takes against the employee.
Gotcha. Well, it certainly isn't like that here. You
No.
test positive just after your accident in the workplace that has led to an injury. If you test positive, you still may be entitled to medical care, but you would not be entitled necessarily to compensation benefits. If, however, let's just say hypothetically you test positive for marijuana, but the accident you were involved in, you happen to be riding in the car and the coworker, the driver was in the accident. It was a 2-car accident, but you were just riding. That had nothing to do with causing or creating the accident itself. You might still be entitled to compensation benefits because your impairment, whether you were impaired or not, had no outcome or input on the accident itself. Mm-hmm. Now, let's take it further. Let's say that into the medical care treatment, 3-4 months on down the road, you decide to add some type of self-help, some type of, and again, I'm going to go back to marijuana, to ease your pain. And then they test you at a random screening. Again, you could be subject to losing your comp benefit. So it's pretty harsh in that regard. So we have to fight that fight. Not often, but enough that it's definitely on our radar screen. But it sounds like it's vastly different than the way it gets treated in Delaware. Heather,
let's not give them any ideas. Let's not give them any ideas for bringing that to Delaware.
We've got one more topic, and this really, a lot of these, we pull these together each month based on our own practices. And right now, David has got a brain injury client who is requiring home health care nursing literally 24 hours a day. And David did such an awesome job of lawyering that he has gotten an agreement where the insurance company, the comp carrier, is going to pay the spouse to be that person. She has the training. She cannot work her job, her normal job, and do taking care of her husband. So David got it to where she is now on the payroll, and it's being paid through work comp to take care of her brain injured husband, which is a great job that David was able to put all of this together. How would that be treated, that kind of a situation in Delaware? Would they be entitled to the same type of benefits?
No, not unless they jumped through significant hoops. Here in Delaware, any workers' comp provider, any doctor, physical therapist, chiropractor, pain management, they have to take a test from the Department of Labor, and they need to become a certified provider. If they're not what we call a certified provider, then they don't get paid. So could the spouse do that? Yes, they could, but workers' comp would not pay them if they don't go onto the Department of Labor website and take that extra certified provider course, obtain that certification, and then issue billing in the proper formats.
And I think part of this, going back to David's case, when you're talking about Medicare set-aside arrangements, MSAs, and we won't dive into all of those details for today, but there are Medicare items that are covered and paid, and then there are Medicare items, that are items dealing with care that are not covered through Medicare. And it was through that avenue, this home health nursing situation, where David was able to get with the insurance company and get an agreement from them for this to be paid that way. And he's going to speak on that in a topic and seminar in the upcoming months once it gets finalized. But it's very interesting how our states, well, granted, the state's laws are very, very different in many topics, but the hoops that we have to jump through are so different at times, just based on what our laws do and do not allow for. But it's all in the same spirit of just trying to get the best benefits we can for our clients.
Exactly. Always trying to fight for the injured worker.
It really is. And I want to give another shout out to the Workers' Injury Law and Advocacy group that we both, plus David, belong to. David is an executive officer, so that's why he's traveling. But Heather, what, in brief, kind of share what has been one of the better benefits? I know we briefly touched on this, but when we get together at these conferences, whether it's the national conference or it's the regional different ones around the country, to me, it's the camaraderie and just being able to freely share ideas and the friendships, of course. But what else is something that you take as a benefit for someone who may be a young lawyer or a lawyer that doesn't yet know the benefits of belonging to one of this national organization.
But you're so right, Bernard. It's all about the friendships and the camaraderie, and the people is what makes the group what it is. We have a listserv that is for everybody that belongs to the group. And we have attorneys from every state in the country that belong to this listserv. If I had a question about Kansas law or about Arizona law, I could type it in and I'd have responses within the hour, because everybody helps everybody else out. And I think there's that sense of belonging, and that sense of we're all fighting the same fight here, that makes it so meaningful and so willing for one to help the other.
You couldn't have said it any better, because that's what drew David into it. And then a couple of years later, I came on board. So I hope that anybody out there who's not a member, if they have questions, get in touch with Heather, get in touch with me or David, and we can certainly share more. There's all kind of scholarships for new people who come into the organization who may qualify to go to conferences and the like. But Heather, thank you for coming on Work Comp today. It really is. I know it's a fine niche, but there's enough of us out there that we work comp nerds need to keep sharing what we see and why it's so important to keep talking about what happens to injured workers, what happens to independent contractors, and the like. And I want to thank you for taking some time with us today.
Of course. Thank you for having me, and thank you for bringing light to such an important topic.
Well, thank you for that. And I always give David the final word, and he always has words of, no, he doesn't really. He just something snarky. but anyway, we'll cap it at that. And just for those of you who watch us, including my mom, each month, we're going to come back again next month in May with another story. Hopefully David will be with us, another guest, another friend or colleague. But again, Heather, thank you again. I hope to see you in person sometime soon, and just keep doing what you do. So thank you.
Thanks, Bernard.
Absolutely. Hang on, Heather, just a second.